Hi, I'm Teddy Holtz. I'm an attorney with Winstead PC. Welcome to the HOA Learning Lab. Today I'm trading in my coat and tie for a lab coat, and I'm very excited about it. I'll be talking about short-term rentals. So first, the definition. There's really no legal definition. As the name suggests, it's a rental for a shorter period, usually less than 3 or 6 months. But on Airbnb, Vrbo, what you usually see and what you usually do, 1 or 2 nights, a weekend, a week or two, or like my friend who does in Lisbon, Portugal for a few months. That's the life, isn't it? There are drawbacks to property associations as far as these go. They can obviously cause a nuisance to other people. You don't necessarily know who's coming and going from the property. You have your general rental issues, which are just an inactive owner, probably not contributing to quorum or voting, that sort of stuff. And then I'll also be focusing on case law and takeaways. So first, Tar v. Timberwood Owners Association. It's a Texas Supreme Court case from 2018. So this Texas Supreme Court was saying Mr. Tar's use of the property did not violate the single-family residential use aspect because he was short-term renting to folks who were utilizing it as a single-family residential family would, that they were sleeping overnight, that they were conducting, eating, drinking, whatever a family does in a property. So they weren't convinced there. They then also looked at the structure aspect of it and said that's really not at issue either, just focusing on the single-family residential use. And that restriction alone was not enough for the court to decide in favor of the association. And really what the court said is that, hey, the association can just amend their declaration to provide for a minimum leasing term. That's how that played out. So next, I want to talk briefly about Chapter 204 of the Property Code. It applies to single-family residential associations in Harris, Montgomery, and Galveston counties only. And it allows these associations via their boards to regulate the use of the subdivision so long as the declaration, the bylaws, or the articles of incorporation do not provide otherwise. Now with that in mind, the Texas Supreme Court in 2022 decided the case of J. Bryce Holdings versus Wilcrest Walk Townhomes Association. In that case, leasing was permitted via the declaration, but then a provision at the end of that restriction stating, other than the foregoing, there shall be no restriction on the right of any townhouse owner to lease his unit. So with that in mind, the association then adopted rules pursuant to their rulemaking authority under Chapter 204 in an attempt to prohibit short-term rentals. The Supreme Court ruled against the association in that case because the declaration specified that there were to be no other restrictions on the right of an owner to lease his unit. Okay, and next I want to talk about Kim versus Old Oaks Community Association. This is a Court of Appeals case out of Houston from 2025. In this matter, the association adopted a resolution via the board, and it implemented a short-term rental policy that prohibited short-term rentals. Now, contrast that with J. Bryce. The Court of Appeals actually upheld that board resolution since the association was located in a Chapter 204 county, and the resolution or short-term rental policy was not contrary to the declaration, articles of incorporation, or the bylaws. So talking about enforcement, it's essential if your association is going to enforce against short-term rentals. So first off, one or more neighbors are often essential witnesses. So what does that mean? They're a witness who you're going to have appear in court should the matter go to trial because the association's case hinges on their cooperation. Having them offer photos and videos of tenants coming and going, and different cars parked at the property are also going to be incredibly useful. Screen captures of the short-term rental listing are also very useful. That is something that the board or the property manager can do as well. Now consider fining. Make sure that your fine and enforcement policies are in place, especially if you're a single-family residential association subject to Chapter 209 of the Property Code. And for major tourist and sporting events, that could be your World Cup, that could be if the Texans ever make the Super Bowl and it's located in Houston, Texas. Then getting an e-blast or a letter to the members reminding them of the rental restrictions and consequences for violations of those are going to be for your benefit as well. All right, well, thank you all for joining me in the HOA Learning Lab. Again, my name is Teddy Holtz. I'm with Winstead PC. And if you ever are in need of legal assistance or advice, always a phone call away, so please don't hesitate to reach out. Thank you.